the Legal Action Center. We've been around for about 30 years. We're an organization that focuses on people with addiction histories, people with HIV and AIDS, and people with criminal records. And I work out of this called the National Hire Network that focuses on the employment needs of people coming out of the criminal justice system. So I'll just begin by talking a little bit about the current status of the still and currently in revision of the criminal justice system through incarceration and the parole and probation systems. Currently, prisons and jails add more than 1,000 people each week a year, which puts it at almost 2.2 million people, or 1 out of every 136 residents being behind bars. As of last summer. So as we know, it's a substantial, big scope in this country right now. Talking about the reach of the criminal justice system and the number of people with criminal records in this country, currently there are over 65 million people who have a criminal history on file with their state government, which equals about 30% of the nation's adult population who live a substantial portion of their lives with a criminal record. We also know that the nation's prison population is aging. Between 1995 and 2003, people between the ages of 40 and 54 accounted for close to 50% of the total growth of the U.S. prison population. And we also know that the percentage of women in the incarcerated population continues to grow at a faster rate than men. We're going to talk a bunch about the different barriers that people face to reentry, and on the federal level, the state, local levels, and different initiatives that are going on at each of those levels to look at those barriers and try to help people reentering. Among the barriers that we'll discuss, untreated drug and alcohol addiction. Here at Legal Action Center, we do have a large focus on looking at the services that people have in the community who have addictive disorders, both in the community and behind the walls. Also look at the role of income in people reentering, the level of education and work experience that people have, the stigma of a criminal record and the discrimination that often leads to, occupational bars and licensing restrictions, and state standards for hiring when we look at employment barriers. Also, the inaccuracy and mistakes on rap sheets that's been discussed often down here, kind of looking at the influx of criminal history background checks and how that, again, can be a barrier to employment for people with criminal histories. Also looking at lack of transportation and lack of family support as barriers to reentering successfully and access to affordable and stable housing. So again, we'll go into more detail on a number of those types of barriers. But first, we're going to talk a little bit about the impact of drug use in the criminal justice system. As we all know, a very large percentage of people in the criminal justice system have drug histories. Research has shown that 80% of state and 70% of people in federal prisons have reported past drug use. A survey of jail inmates in 2002 found that 2/3 of those people were regular drug users, and over half reported using drugs in the month before the offense, leading to incarceration. We also know at arrest, between half and 80% of adult men tested positive for illicit drug use, and we know that this is something that is around the country, that addiction affects people of all different background, race, income, gender, that across the board it's a significant problem both within the criminal justice population and the non-criminal justice population. So we'll talk a little bit about funding for services and how a lack of federal funding and public funding generally is a real barrier for people trying to reenter successfully from the criminal justice system. We know that while incarcerated, when we're looking at people incarcerated in state prison, only about 1 in 5 individuals receive treatment. And again, looking at the numbers of individuals we know who needed treatment for a drug or alcohol addiction problem, this is really, not even scratching the surface. People are not getting the help they need in that sense. We also know that the Substance Abuse and Mental Health Services Administration, which is an agency in the federal government's Health and Human Services Department, has shown that although there were over 23 million people who needed treatment for an addiction, only 2.3 million people received it, which means that there are about 21 million people in this country who, again, clinically met the definition for needing treatment for a drug or alcohol problem that did not receive that treatment. And again, we know that there's a huge intersection between people in the criminal justice system and people who need these critical treatment services. We also know, in looking at the funding picture, that on the federal level, where I work here in Congress, the money has not increased and has not kept even pace with inflation. The Residential Substance Abuse Treatment Program, which provides treatment for incarcerated people in the states, funding has been cut repeatedly over the past number of years. And we also know that funding out in the community through the Substance Abuse and Mental Health Services Administration, again, has not received the types of increases to deal with the growth of need. Talk a little bit about barriers for people with criminal records that are specific to drug-related crimes. We know that barriers in state law that pertain to employment include licensing restrictions and occupational bars. There are hundreds of different types of jobs that require some type of licensing, registration, or certification by a state agency, so that is certainly a barrier to employment for people with criminal records. Also, there are a number of barriers that are a combination of state and federal laws, which include the Food Stamp and Cash Assistance Program that we'll talk a little bit more about, and barriers to people with criminal records receiving driver's licenses. And then, in addition, there are some additional things that are barriers through education, housing, and voting that are due to federal law. But first up, we'll talk about employment. As I mentioned before, there are a host of different licensing restrictions and occupational bars that exist at all three levels that serve to limit the employment prospects for people with criminal histories. And this information that we'll talk about specifically on unemployment and on a number of different other topics can be found in a publication that we did a couple of years ago that some of you may have heard of. It's called After Prison, Roadblocks to Reentry. And the last slide in the presentation will actually include a link to that report that can be found on Legal Action Center website and also the National Hire Network's website. And as I mentioned in the previous call, we are in the process of updating that report. We know that it was done a couple of years ago, and that in that time a number of states have made changes to their laws that we would like reflected. So be on the lookout for an updated, revised version of that. But going back to speaking about employment barriers, most states currently allow employers to deny jobs to people who have been arrested but never convicted of a crime. So that's dealing just exclusively with arrest records. Currently, also, most states allow employers to deny jobs to anyone with a criminal record without looking at how old the record is, how minor it may have been, and also looking at the individual's work history and personal circumstances related to the crime the person was convicted of. These restrictions lead to fewer employment opportunities and, accordingly, a significant loss in earnings. One recent study found that having a criminal record led to a 50% reduction in employment opportunities for white applicants and a 64% reduction for African American applicants. Moving on to access to food stamps and cash assistance, the barriers that pertain to people with criminal records there. In 1996, Congress did a major effort to reform the nation's federal welfare law, which is the Temporary Assistance for Needy Families, or TANF program. And in that law, there is a provision that prohibits anyone convicted of a drug-related felony from receiving federally funded food stamps and cash assistance. This ban is a lifetime ban, so even if a person has completed his or her sentence, has overcome an addiction, and has been employed but then laid off or earned a certificate of rehabilitation, it doesn't matter. This is a lifetime ban. However, states can either maintain this ban on cash assistance and food stamps, or they have the option of passing legislation to either limit the ban or to eliminate it entirely. Currently, there are 16 states who completely deny benefits on the basis of this ban. 21 states have modified the ban, and 16 have eliminated it completely. It's estimated that there are nearly 100,000 women and 150,000 children who are in states where the ban has been enforced that have been affected by this ban. In addition, most states restrict at least some people with felony convictions from being able to access this public assistance, as I mentioned before. We could talk a little bit about driver's licenses. Again, when we're talking about the ability of people to get to jobs, to be able to, not recidivate after they've come out of prison. In 1992, Congress passed a law that currently withholds 10% of certain federal highway funds unless a state enacts and enforces a law revoking or suspending for at least 6 months after the time of conviction the driver's license of a person who is convicted of any drug offense. Here again, states can decide to opt out of the law by either limiting the revocation or suspension to drug crimes related to driving specifically, or to other more limited categories of crimes. Currently, 27 states automatically suspend or revoke licenses for some or all drug offenses, and the other half only suspend those or revoke those licenses based on driving-related offenses, or they have opted out of the federal law entirely. We can talk about barriers to higher education.
Gabrielle,
yes.
I'm going to interrupt you for just a second.
Yeah.
And ask if we had a couple of late joiners that please press *6 to mute your phones. If you don't have a mute button, so I hear a little bit of background noise during your presentation. We want to try to avoid that. Again, *6 to mute your phone if you don't have a mute button. And we will have opportunity at the end to open up the lines again if you have a question. Thanks. Sorry for the interruption.
No, thank you, Jean. Okay, we'll move on to higher education, talking about Pell Grant eligibility for incarcerated people. In 1994, Congress removed Pell Grant eligibility for incarcerated people, which was able to give people support for post-secondary education behind the walls, despite knowing that post-secondary education does dramatically help to reduce recidivism up to 30%, and the relationship between education and employment. States have since struggled to provide post-secondary education efforts for people who are incarcerated, so that's an existing barrier. An additional barrier is a provision in the Higher Education Act, which makes students convicted of drug-related offenses, those are both felony and misdemeanor offenses, while they're enrolled and receiving aid in school, ineligible for any grant, loan, or work assistance. This federal barrier is one that cannot be altered by states. You may have heard that this was something that was actually changed about a year ago, where before the change to the law, this applied retroactively, so people who had past drug convictions would be banned or their aid would be denied. The law was changed to only penalize people who are in school and receiving aid when they get their conviction. So a little more detail on this. Financial aid is suspended on the date of the conviction for varying lengths of time. They have kind of a timetable that depends on how many offenses the person has been convicted of. In addition, a person convicted of a drug-related offense who is in school can become eligible for a student loan before the end of the suspension period if he or she completes treatment that's approved by the Department of Education and that person passes two unannounced drug tests. In addition, eligibility for financial aid may also be reinstated if the conviction is reversed. So those are some of the barriers to education. Next, we'll move on to housing. There are a number of federal laws that require local housing agencies to permanently bar people convicted of certain sex crimes and methamphetamine production on public housing premises. There are also, these laws give a lot of discretion to public housing agencies to deny eligibility to virtually anyone with a criminal background. These local housing authorities have considerable leeway to consider individual circumstances and history of applicants. They can, for example, they can decide whether arrest records that did not lead to conviction can be considered in eviction proceedings. They can also determine how long to deny housing assistance to people with criminal records and decide what, if anything, qualifies as rehabilitation for the purpose of lifting the bar to public housing. Next, we'll talk about voting. Here, states have absolute power to decide whether someone with a criminal record can vote. Currently, all but 2 states place some restrictions on the right to vote for people with felony convictions. Next, we're going to talk about some developments on the federal level and then on the state levels to, again, look at some of these barriers. First, here in Congress, the Second Chance Act, which is legislation that has been floating around for the past few years that our organization has worked in support of, is going on in Congress. It basically would provide a big grant program, well, not that big, I apologize, that it would authorize about between $50 and $65 million for a grant program through the Department of Justice, where states, localities, and community-based organizations could apply to receive funds to support their services for people who are returning from the criminal justice system. Among these services including addiction treatment services, mental health, medical services, housing, employment, and some mentoring services. It would also provide for a review of state and federal barriers that prevent access to housing, education, employment, and other benefits. And just to give a little status check, this has been kind of moving through. It's been introduced in both the House and the Senate this session, and it has both Democratic and Republican support. We came the closest we've ever come to getting it through the House very recently. It almost came to a House floor vote, and we are hopeful that it will come to a House floor vote, just from legal action center's perspective, very soon again. So, and I mentioned earlier that the National Highway Network and the Legal Action Center does have a number of free electronic newsletters updating people around the country on different developments, looking at policy affecting people with criminal records, addiction histories, and HIV and AIDS, including updates on the Second Chance Act, which I know a number of people around the country have been hearing about and are curious about kind of the status. So feel free, at the end is my email address. If any of you would like to be added to these lists, feel free to email me, and I'll make sure you're able to get these updates. Moving on to other possible solutions to help ease some of these barriers that people reentering experience. First, investing more funding into community-based drug and mental health treatment services. As I mentioned before, we know the need in the community, and that people, as I mentioned before, they've estimated about 22 million people need these services and are not getting these, critical services. And it's really, the public funding system is really the major contributor to help fund these services. So that's something that the federal government can do. Also looking to expand the EITC, the Earned Income Tax Credit, to low-income workers who are not raising children. It's currently limited to people with children. And then looking at repealing or modifying the federal restrictions that I mentioned before, first being reinstating eligibility to incarcerated people for Pell Grants to finance post-secondary education while people are in prison. Also the financial aid ban through the Higher Education Act that I mentioned before that either delays or denies aid to people convicted of drug crimes while they receive aid. Also the drug felony ban on TANF welfare benefits and food stamps that we discussed before, federally assisted housing restrictions, and laws governing driver's licenses. Talk a little bit more about additional national solutions. First, again, on the employment issue, which is so critical to people being able to reenter successfully. The Equal Employment Opportunity Commission, the EEOC, does have guidelines that help to tell employers how they can look at people who are applying for jobs with criminal records. And putting these guidelines in statute or codifying them, we feel would strengthen the rights of people with criminal records and the ability to obtain employment. Currently, these guidelines say that employers may not exclude people based on arrests that did not lead to conviction unless there is a business justification. And that business justification would lead to the questions of whether the arrest is related to the job and looking at the length of time since the person was arrested. In addition, the EEOC guidance contains a provision stating that the employer may only exclude a person because of a conviction if there is a business necessity there. And looking at how a business necessity is determined, the employer must consider the nature and severity of the offense, the time that is elapsed since the conviction and or the completion of the sentence, and the nature of the job held or sought. Excuse me. Okay, then we look at changes at the state and local levels. As we discussed before, in a number of instances, states could use discretion granted by federal laws to ease barriers. As we discussed, the TANF ban on food stamps. Excuse me, my throat is very dry. I'm going to take a sip. Hold on a moment, please. Okay, I'm back. I'm sorry. So states could use discretion granted by the federal government to ease barriers, as a number of states have, with the TANF and ban on food stamps and cash assistance. Also, the federal government rule on driver's license and public housing authorities and voting. States could also provide for sealing an expungement of arrest records that have not led to a conviction, and if conviction records after a certain amount of time deemed appropriate has elapsed. Currently, 33 states do not allow expungement or sealing of records. 40 states do allow sealing and expungement of some or all arrest records that did not lead to conviction. When we continue to look at state-level solutions, again, we go to the employment area and looking at enacting hiring and employment standards, ensuring that eligibility for employment is based on the community's interest in public safety, and that an individual's history and circumstances are taken into consideration. Currently, 29 states have no standards governing the relevance of conviction records, and 21 states do have standards that require a direct, rational, or reasonable relationship to justify the agency's denial of a license. So again, developing these employment standards to give employers the guidance needed to make good hiring decisions that, again, to hopefully not limit employment opportunities for people with criminal records. Additional developments on the state level, certificates of rehabilitation, where employers in a number of different professions are barred from state licensing agencies from hiring people with a range of criminal convictions, even if the criminal convictions that are unrelated to the job or license sought. Certificates of rehabilitation would serve to lift the bar to employment for certain professions. And although all states have this power to develop these certificates of rehabilitation and implement systems in their states, currently Arizona, California, Connecticut, Illinois, Nevada, New Jersey, and New York are working on these certificates of rehabilitation. Also look at tax credit programs on the state level. A number of states have created tax credits for employers who hire job applicants with criminal records. And states also have statutes that allow for the receipt of tax credits for any business that contributes to crime prevention. Now, just 3 quick examples on the local level, and then I will close up. First, Chicago has done some really interesting work recently. Their City Department of Human Resources has issued guidelines imposing standards on all city agencies on hiring people with criminal records. This guidance requires all agencies to take into account the age of an individual's criminal record, the seriousness of the offense, evidence of rehabilitation, and other mitigating factors before they make the hiring decisions. In addition, there's a plan to revise the city's job applications to remove the question about criminal history and defer the criminal background check until later in the hiring process. Similarly, in St. Paul, Minnesota, the mayor has issued a memo to the city council directing the Human Resources Department to look at its hiring process regarding people with criminal records. Again, the city will remove the criminal history question from job applications and will delay the criminal background check until the final stages of the hiring process. The mayor has also been working with the private sector in order to play a major role in promoting reforms to remove unfair barriers to employment for people with criminal records. And finally, San Francisco, they are also looking to remove that question from the job application on whether a person has a criminal history and look at the person's conviction history later down in the hiring process when the applicant has been identified as a serious candidate for the position. So finally, just speaking again from the federal level, which is our perspective down here, we have seen some progress that's, educating members and their staff about the needs of people coming out of the criminal justice system and the types of services that need to be in place to help people get acclimated to the community, and a real need to look at these barriers through the Second Chance Act, which again would provide a review of barriers on the local, state, and federal level. So we are encouraged by that. And then finally, the contact information. Again, feel free to contact me if you have any additional questions after this call on any types of federal initiatives that are going on related to people's criminal records. Thank you.
Thank you, Gabrielle. We are going to transition over to a local perspective from Carlette Duffy, who is the Regional Director in Indianapolis for AIM, which is Aftercare for Indiana through Mentoring. AIM is a juvenile reentry program whose primary focus is the successful reentry of juvenile offenders through mentoring relationships with positive adults. She's also the founding member of MOVE, which stands for Members of the Village Empowered, which is a local initiative started in Indianapolis that she will talk about in a minute. I'm going to hand over the floor to Carlette and let her kind of give a different perspective, more of a local perspective versus a national perspective that we got from Gabrielle. And then after Carlette is done with her presentation, we will open up the floor for questions for both of them.
Thanks, Jean.
Thank you.
Just to kind of let people know exactly how this is reflected in Indiana, from what Gabrielle was discussing, Indiana itself is an at-will state, which basically means that employers can hire and fire as they see fit. So criminal history does not have to be said to be the issue of why they are hiring or firing someone. Our city director of public safety and the executive director of the African American Male Commission here in Indianapolis approached myself and a couple of other people who are active in the community and asked us to see if we could put together a group that would work to help people who have felony convictions. And so we came up with the name MOVE, which stands for Members of the Village Empowered. And MOVE is a not-for-profit public benefit corporation that is registered with the state of Indiana. It is comprised of and primarily for people with felony convictions and their families so that they can help themselves by exercising collective bargaining power, form a voting bloc, and provide financial assistance to its memberships. I really enjoy the advocacy piece of this as well. I advocate for members in the areas of parole, probation, home detention, and the court system. The members of MOVE Incorporated envision an environment in which people with felony convictions can be fully reintegrated and contributing to society with dignity. To accomplish this, MOVE's mission will include taking advantage of opportunities to advocate on behalf of its membership, formulating and proposing legal legislation agenda that benefits its membership, maintaining the means for the organization to be financially self-supporting, and among things, to allow for an inviting and caring opportunity for its members to engage in social healing. The biggest thing about reentry for us is that most people have issues with the fact that they never saw the part of society. So if we can talk about the current law for a second, Indiana does not have a law for expungement at this time. We do have a law in place for a code in place for a sealing of criminal histories. And a person may petition the state police department to limit access to a person's limited criminal history to the criminal justice agencies if more than 15 years have elapsed since the date the person was discharged from probation, imprisonment, or parole, whichever is later. And typically parole or probation is later for the last conviction of the crime. In January of, I'm sorry, my papers are out of order. Oh, you're fine, Gene. Thanks. For the current law, the problem is that the recidivism reality, as it is for the Department of Justice and also for the state of Indiana, is that most people recidivate. It's judged by a 3-year span. So if they're looking at in terms of 3 years, someone returning to the prison system because they have committed another crime, then there needs to be things in place for that 3-year span versus a 15-year span. Indiana has approximately 16,000 people returning from the prison system alone. And for 92 counties located within Indiana, in Marion County alone, where Indianapolis is located, 4,400 of those 16,000 are returning here, and which kind of closely reflects exactly what is going on nationwide with the 272,111 offenders discharged in 1994 that had accumulated 4.1 million arrest charges before their most recent imprisonment, and another 744,000 charges within 3 years after release. New to our legislation this year was House Bill 1230. This is something that the representatives have come to the community and asked our opinions on, and we touched base with a lot of different legislators in the state to find out exactly what their opposition would be to this. And the biggest opposition that we've had is in the terms of the years that have passed since the conviction. So the synopsis of this legislation was an expungement of certain felony conviction records allows the sentencing court to expunge the record of certain felony convictions committed before a person was 25 years of age. If 25 years of age, if 12 years have passed since. One thing about this issue is that having committed a crime before 25 years of age excludes a number of people who have been in good standing since their conviction because they have committed their crime after the age of 25. One thing that MOVE has done to get the word out and show the support of this bill of 1230 and let the legislators know that this is something that the community drastically needs is we formed a march, a rally to the State House, about a 1.5 mile walk, and we passed out flyers, and this is the flyer that we passed out. And basically, we just wanted to let them know what the people felt about this type of legislation and that we were behind it. We wanted them to tell us, and we actually had people here from each representative community that had voted no on this to say that they were an actual registered voter in their community and they wanted to know why. So it helps us to dictate what we do next. And as far as how far we went with this legislation, what's the next one? Representative Vanessa Summers and Representative Greg Porter were the two authors of the bill, and they were phenomenal in working with us and helping us to get this legislation through the system. On January 11th of this year, the bill was read and referred to committee. It did pass out of committee, which is the first time that this has ever happened for expungement on legislation in February. Unfortunately, it was defeated on the House floor, but it was only defeated after hours of debate and questioning. So I think it was very remarkable that it was able to happen. And just in closing, I just wanted to say also that in the process of us trying to push legislation forward in this community, we're also working to help people right now. So we've talked to our city county council members and explained to them the importance of working with employers and contractors to increase their acceptance of hiring people who have felony convictions. So they have put that into a lot of their contracts, is that they want people, anyone that's contracting with the city of Indianapolis has to expect a certain number of applicants to be people with felony convictions. And then we took it one step forward and asked the city to do that themselves. If they're going to request that of their contractors, we would expect them to do it as well. And they have actually met that goal, and they are doing it also starting this year. They have been accepting applications and hiring people with felony convictions that are in appropriate roles. And that is about what we're doing.
Great. Thank you very much, Carlette. And Gabrielle as well. I want to go ahead and open up the floor for any questions that you may have for either presenter. Again, it's *7 to unmute your phone if you've already done that, or if you have a mute button, you can go ahead and open that up. I just ask that you identify yourself with a name, and we'll go ahead and acknowledge you. You can also raise your hand electronically, and we'll acknowledge you that way as well.
McFarland in the Department of Justice. I had a question for Gabrielle on slide 19. At the bottom, you say that 5 states have statutes that allow for tax credits for businesses contributing to crime prevention. What kind of contributions are qualify for those tax credits in any of those states?
I am not sure, to be honest. I will find out, and can I email that to you, Jean, to email out, or I can send that directly to you, Steve?
Great. I'll just email Jean my email.
Okay, great. Thank you.
Thank you.
Thank you. Do we have any other questions?
This is Carlette. I have a question for the gentleman. Are you referring to what contributions the company itself has to commit to?
Right. Yes.
Okay. With that, it's basically the level of employment, be it full-time with benefits, and then the tax credit for Indiana, as I know it, is only for 1 year after the release of the individual. So for them to be employed, anytime after that, then they're not eligible for the tax credit.
So the Indiana tax credit is a credit for hiring an ex-offender. It's not for anything else that contributes to crime prevention. Is that right?
That's correct.
Okay. So maybe on that slide, the Indiana really belongs in the bullet right above it, where it's a tax credit for employers who hire those with records.
Yeah, well, I've looked at the National Hire Network's website, and it's phenomenal. I really do love it. And there's a lot of information on there that really can assist you. Right. But I can tell you some of the things that we say we do, and I mean, having worked in this field, I'm sure you know, there are things that we say we do, but then they're manipulated here and there to where it's not quite exactly what we do.
And I know, and as I mentioned before, thanks for that shout out, Carlette. We appreciate that. We are in the process of doing our 50-state report card over again. And, again, I think it was done about 3 years ago, and there have been a number of changes to different state laws and regulations. But I will get that specific information to see what the text of the statute actually is.
Well, this is all very helpful. You're doing a great job. Thanks.
Good.
And change is good. It'll get better.
We think so.
The other thing I kind of wanted to highlight is the sentencing project also has a state-by-state guide, more on the collateral consequences, some of the things that Gabrielle mentioned in terms of voting rights, expungement laws, and that's they have a guide of what the laws are by state. It was updated earlier this year. So that website is also online. You can visit the Sentencing Project website and see some of those. Not necessarily doesn't have the information that the Harry Network has in terms of employment and that kind of information, but it's more on voting rights and expungement laws and kind of driver license, that other kind of collateral legal barrier information. Any other questions? Again, star 7 to unmute your phone. We want to make sure to give the opportunity to others. I do want to mention that if you want to share some of the information that we've talked about in this presentation, we are recording this. It's going to be available if you see the website that's currently on your screen, nationalservice.gov/resources. You can just put the keyword reentry, and it'll take you to the list of webinars that we've done in the past. We did do a specific webinar with the National Hire Network on public-private ventures on employment. So feel free if you want to kind of go over that presentation, and we'll have this one uploaded within the next day or two as well. I'm sorry, did someone have a question? Okay, if we don't have any other questions, I do want to make sure that we did have the information for Gabrielle up. I can also, if you want to email Carlette specifically, please feel free to email me, and I'll put you in touch with either one of our presenters.
Gene?
Yes?
Just for the benefit of the rest, this is McFarland again. There's a good article that was in Criminal Justice Magazine, fall of 2006, that has a report card on the collateral consequences of conviction. It's entitled "The Debt That Can Never Be Paid."
I also, and then keep one for yourself.
By Margaret Love, and it's
very beginning of our meeting.
I think that we have some background on that. And actually, the Sentencing Project website that I mentioned, it's updated by Margaret Love.
Oh, good.
So it's her information as well. That's the collateral consequence information. It's based on, she also has a book on collateral consequences, and it's actually an excerpt from that book.
Yeah.
Okay. If we don't have any other questions, thank you very much for the comments. Thank you, Gabrielle and Carlette. And I will be emailing those of you who were on this presentation with an evaluation, and we appreciate any feedback that you have. If you have any questions that you couldn't think of before, please feel free to email those to me, and I'll forward those to the presenters.
Thanks a lot for doing this.
Thank you, Jean. Thank you. Now, I will say this real quick. I did appreciate, I learned some new information actually regarding the TANF funding. That's something that a lot of the women that are coming out of the system are dealing with here in Indiana. Unfortunately, our women's facility is at 186% capacity right now. And a lot of it has to do with drug usage. So that'll be our next fight now that I know that it's at the state level, and everyone at the state level has been telling me that it's a federal issue. So
no, that's
good to know that.
Right. Good. No, and we're happy to give you any more information. The states have done, fantastic work around the country on this.
Mm-hmm.
So it's something that's definitely moving forward and definitely ripe for action.
And I'm also really glad that you mentioned that the HUD regulations only bar meth production and sex offenders from public housing, and because the feds are always blamed, and it's understandable, but the housing authority folks don't want to tell a 6'6", felon that that you just don't like the looks of him, so you're not going to let him in. You just say, well, I'd love to let you in, live with your girlfriend here, but the feds back in the HUD don't let me.
I hear that all the time, and actually our housing executive, I asked him, I said, will a felon conviction bar someone from receiving Section 8 vouchers because they had an open call for it? And he said, we will take it on a case-by-case basis.
Well, that's the problem.
I said, so you're telling me no? He said, we'll take it on a case-by-case basis. So you're telling me no? He was telling me no.
Well, and that may be the worst of all worlds. I don't like the way you look. I don't like your skin color. I don't like your gender. I don't like the crime you committed. I mean, case by case.
Yeah, very true.
I mean, it's just ripe for discrimination.
Very true.
Keep up the good fight.
Thank you. Thank you.
Thank you.